My name is Adam Parrott, and I've been organizing with 911truth.org for the last couple of years. Now I'd like to introduce our moderator for this evening, Dr. Richard B. Lee. He's a University Professor Emeritus of Anthropology at the University of Toronto, and he holds a cross appointment at the Centre for International Health and is a Fellow of the New College. He has held academic appointments at Harvard, Rutgers, and Columbia Universities, and research positions at Stanford, Australian National University, and Kyoto University. He is internationally known for his ethnographic studies, starting in 1963, of hunting and gathering societies. He has published 6 books and over 100 articles and chapters. A Fellow of the Royal Society of Canada and past President of the Canadian Anthropology Society, Lee holds honorary doctorates from the University of Alaska, Fairbanks, and Guelph University for his research and advocacy on behalf of Indigenous peoples. So would you please give a warm welcome to Dr. Richard B. Lee.
Thank you, Adam, and thank you to all of you for coming out on an evening when there's, here in Toronto, there's interesting other events of a similar nature going on elsewhere. So I'd like to introduce now Professor Michael Keefer of the University of Guelph. He's a professor of English and former president of the Association of Canadian College and University Teachers of English. He's published widely on questions of textual evidence in early modern literature and philosophy, as well as such intriguing questions that are relevant to tonight's proceedings as contemporary electoral fraud in U.S. presidential elections, Canada's role in Haiti in the troubles in that benighted country, and finally his work on Canada's role in the war on terror. And I understand that that is the direction that Professor Michael Keefer will take us this evening. Welcome to Toronto.
I'm honored to be sharing a platform with the distinguished economist, Professor Paul Zarembka. And I'd also like to thank Professor Richard B. Lee, our host at this event, for making it possible. Now, a brief reflection on the career of Professor Lee can provide us with an appropriate point of entry to the topic I'm addressing this evening: Canada's role in the war on terror. Richard Lee is an emeritus university professor at the University of Toronto, a fellow of the Royal Society of Canada, a foreign honorary member of the American Academy of Science, and, as you've already heard, an anthropologist of worldwide distinction. He's also, and this has been an integral part of his anthropological research and scholarship, a committed public intellectual. Consider the title of a book he co-edited more than 30 years ago: The New Native Resistance, Indigenous Peoples' Struggle, and here's the part of the subtitle that I think is interesting, particularly interesting, and the Responsibility of Scholars. The New Native Resistance, Indigenous Peoples' Struggle, and the Responsibility of Scholars. Or the title of one of his many articles, Colonialism, Apartheid, and Liberation, or the very appropriate title chosen in 2003 by the editor of a Festschrift, a collection of essays published in Professor Lee's honor, The Politics of Egalitarianism, Theory and Practice. In his decades of work in support of the politics of egalitarianism, Richard Lee has been a staunch defender of human rights, and in particular the rights of Indigenous peoples. He's been active in HIV/AIDS research and advocacy, and as I think you've already heard, in 2005 he became the first academic in this country to devote a university course to close skeptical analysis of the evidence relating to the terrorist attacks of September 11th, 2001. I'm going to write something on the board here. That looks like It is Greek. That's the English transliteration of the word. The Greeks of the age of Pericles had a name for the kind of outspokenness that we see in Professor Lee's career, which they regarded as a crucial and defining feature of their democracy. They called it parrhesia, a word that's sometimes translated as meaning free speech. But as the French philosopher Michel Foucault demonstrated in a series of lectures devoted to exploring the classical origins of what he called fearless speech, parrhesia carries further meanings as well. It is speech for which the speaker takes full responsibility, vouching for the truth of its content. And there's a related verb, parrhesia zesthai, which means to tell the truth. This speech arises out of a sense of duty, of responsibility to the good of others and oneself, and it entails the very clear risk that the political authorities or the democratic majority to whom this speech is addressed may react with anger and with punitive measures against the parrhesiastes, the citizen who has dared to speak truth to their power. So what does Richard Lee's example lead us to? A recognition, I would suggest, that the forthright public presentation of what may be unwelcome or unpalatable truths is no less crucial a function in our own society than it was in the democracy that flourished in Athens nearly 2.5 millennia ago. And a recognition as well that it is the particular responsibility of scholars, as people who have devoted their lives to research, to critical inquiry, to an endless refinement of its methods and protocols, in short, to the sifting out of truth, that it is the particular responsibility of scholars to exercise this essential function of skeptically seeking out truth and, whatever the risks, of speaking truth to power, when necessary, of speaking truth against power, and perhaps above all, of speaking truth to and on behalf of the victims of power. Now, we might want to expect our journalists to do this job. As I think we all recognize, it's an unfortunate fact that today's corporate media have very largely dispensed with investigative journalism. Now, I want to point to a recent column by Jonathan Kay, October 27th, 2008, in the National Post, which contains what I think is an admirably frank admission of the predicament faced by pundits in the media who are asked to speak out on subject after subject after subject and are not given the time, or perhaps don't have the inclination, to inform themselves adequately on the subjects on which they're asked by their employers to exercise expertise. Now, what prompted this, I think, admirably frank admission is a recognition that the responses to his own, in his words, purely instinctive dismissals of 9/11 skepticism as, quote, complete nonsense, were coming from people, a large proportion of whom were calm, rational, and conspicuously much better informed on the subject than he himself was. I think that's an interesting admission, and I would add that it comes from a journalist who, a month previously, had written what I regard as a very fine piece on the Omar Khadr case, saying, here are the facts, which he had researched, here are the ethics, and here's what our government should be doing about the shameful fact of a child, possibly a child soldier, but still a child, arrested, tortured, and on trial for his life before a kangaroo court. Now, of course, there have been reasons why academics, different reasons I suppose, have also backed away from parrhesia. When I first began in 2003 to give somewhat hesitant public expression to my growing skepticism about the official accounts of what happened on 9/11, I was warned by a very dear friend, who's also a distinguished professor of American political science, not to touch the subject, any involvement with which would result in permanent damage to my academic reputation, such as it might be. Now, I didn't take this advice or the similar advice a little more than a year later of another friend who wanted to steer me away from publishing analyses of how the Bush Republicans had stolen the 2004 presidential election. As a textual scholar, Michael, what do you know about this? How are you going to invade the territory of political scientists? Well, if one does textual analysis, if one does critical thought, if one does careful, methodologically alert research, disciplinary boundaries don't mean anything. And it occurred to me to wonder what value there could be to markers of professional standing which served not to encourage, but to block inquiry into questions of historical truth and material reality. Or on the other hand, what claims to courage and integrity could be made by public intellectuals who fold their tents at the first mere threat of scurrilous handling by opponents. Now, I think it's worth asking ourselves how well the work of paresia has been done over the last, shall we say, 8 years. And there's a very interesting recent column by Glenn Greenwald at Salon.com, a searching meditation on the humbling fact that what he calls the transgressions and abuses of the Bush regime's 8 years in office were, quote, allowed to be unleashed with so little backlash and resistance. Just consider, with no hyperbole, says Greenwald, what our government, our country has done. We systematically tortured people in our custody using techniques approved at the highest levels, many of whom died as a result. We created secret prisons, black site gulags, beyond the reach of international monitoring groups. We abducted and imprisoned even U.S. citizens and legal residents without any trial, holding them incommunicado and without even the right to access lawyers for years while we tortured them to the point of insanity. We disappeared innocent people off the streets, sent them to countries where we knew they'd be tortured, and then closed off our courts to them once it was clear they had done nothing wrong. We adopted the very policies and techniques long considered to be the very definition of war crimes. Here's Greenwald still more. Our government turned the NSA apparatus inward, something that was never supposed to happen, spying on our conversations in secret and without warrants or oversight, all in violation of the law, and then once revealed, acted to immunize the private sector lawbreakers. And that's to say nothing about the hundreds of thousands of people we killed and the millions more we displaced with a war launched on false pretense, and on and on and on. I think I'd want to correct his figures a little bit. I believe the more accurate accounting of the number of dead due to the invasion of Iraq is more like 1.2 million at the moment. Now, Greenwald proposes that while prime responsibility for these actions may, quote, lie with the administration which implemented them and with the Congress that thereafter acquiesced to and even endorsed much of it, unquote, the blame for this largely unhampered criminality, quote, also lies with much of our opinion-making and expert class, unquote. So you can take those categories as meaning our journalists, our pundits, and also our academics, our think tank people, whatever they are. I don't really think of them usually as being academics, but people with some pretense to scholarly status. Greenwald again, quote, even when they politely disagreed, they treated much of this, and still do, as though it were reasonable and customary, eschewing strong language and emphatic condemnation and moral outrage, while perversely and self-servingly construing their constraint as some sort of virtue, a hallmark of, and he gives a capital S to this word, seriousness. Meanwhile, those who objected too strongly and in disrespectful tones, who described the extremism and the lawlessness taking place, were dismissed by these same elites as overheated fringe hysterics, unquote. Now, Greenwald's essay points to a widespread and dismal failure among a large part of what have sometimes been called the chattering classes, most particularly among those accredited and given platforms and audiences by the corporate media. But for salutary counter-evidence of a gathering wave of resistance to the official account of the event that above all served to legitimize the other crimes of the Bush administration, including the whole toxic system of its war on terror, one can turn to the website Patriots Question 9/11, which contains brief statements by some 1,500 people, including senior military and intelligence officers and government officials, pilots and aviation professionals, academics, among them distinguished scientists, as well as humanists and legal scholars, and some 600 architects and engineers. It's interesting, I don't check this site very, very frequently. The last time I looked at it, there were about 300 architects and engineers. Some 5 or 6 months later, that number had doubled. And these include, I mean, some of the architects and engineers are students of architecture, you know, recent graduates in engineering. Some of them are people with 40 years experience, heads of companies, very senior people. We might well have to acknowledge that forms of behavior very much like those excoriated by Glenn Greenwald have been widespread in recent years among much of our own Canadian opinion-making and expert class, among whom serious criticism of the current orientation of Canadian foreign policy or of the immense damage done to our system of jurisprudence by anti-terror legislation and the ensuing violations of normal legality have all too often been met by scoffs or titters. We might, on the other hand, take some comfort in the fact that a healthy sprinkling of the questioners, the parrhesiastes, whose statements appear on that website, are Canadians. Notable among them, my Guelph colleague, fellow of the Royal Society of Canada, the philosopher John McMurtry, the textual scholar and founding director of McMaster University's Institute for Peace Studies, Graham McQueen, the development economist and founding editor of the Global Research website, Michelle Chossudovsky, and the distinguished investigative journalist and media critic, Barry Zwicker. Now, we've slipped sideways into the subject of my talk this evening, Canada's role in the war on terror. I hope you can hear the scare quotes around that term, war on terror, because one of the very first things we need to do is to question and revise that phrase. President Bill Clinton was already talking in the 1990s about a war on terrorism, one product of which was, of course, his criminal cruise missile attack on Sudan's major pharmaceutical factory, which American intelligence had idiotically misidentified as a chemical weapons facility. Noam Chomsky has estimated that that attack led indirectly over the next number of years to the probable deaths of some 10,000 Sudanese as a result of the medications that were no longer available in that country. But the contracted form of a war upon an abstract noun, a war which involved the fabrication of a largely mythical but quasi-state enemy, and legitimized an endless series of wars of aggression. You remember these statements of Rumsfeld and Cheney that, you know, this is a war that's going to go on for maybe a century, they said with obvious eagerness. Together with the deliberate demolition of all of the human and civil rights protections provided by the United States Constitution and Bill of Rights, that war on terror was the invention of the neoconservative ideologues who came to power in the George W. Bush regime with the judicial coup d'etat that overturned the actual results of the 2000 presidential election. That's something to remind ourselves of, that perversions of legality underlay the coming to power of these people. There's very good scholarship, conclusive scholarship, to show that George Bush was not elected in 2000. That the Democratic, that his opponent won both the popular vote, Al Gore won the popular vote, and also won Florida by a wide margin, had the votes been counted. And as an interesting instance of the corruption of American journalism, that a consortium of American newspapers actually did the counting following the election and then misidentified the results. If you read the headlines of their reports, you learned that their study had shown, after all, that Bush was rightfully elected. If you read the article, you learned the opposite. Now, in 2004, Bush, not having been elected to begin with, was very certainly not re-elected. And there's very good evidence by a multitude of university scholars and citizen activists, statisticians. There's a vast volume of research to show that. And I think it's worth adding that there's also, I think, significant body of evidence to suggest that the reduced level of corruption in the 2008 election is very largely due to the presence of, the very active presence of citizen activists and scholars intervening in the period prior to that election. Karl Rove, a month before the election, was confidently predicting victories in some 10 swing states. Immediately before the election, he was conceding defeat, not particularly because the polls had changed, but because a man named Connell, who had been one of his major computer fraud experts, was up before a court, dragged there by Ohio lawyers and citizen activists, and Rove was simply not able to do what he very clearly wanted to do. So I think we owe, in part, we owe the fact that whatever the consequences are going to be of Obama's election to the activism of hundreds and thousands of American citizens determined to recover their democracy. I said we need to redefine this phrase, war on terror. War always involves terror. And what we're looking at, I think, might more aptly be described, and I'm thinking here of an article in the current issue of Harper's by the very noted human rights lawyer Scott Horton, as a war against legality. A war against legality, making use of all of the weapons of terror. I want, though, at least to touch on a number of different issues. One of them, Canada's participation in the occupation of Afghanistan. I want to talk briefly about the degradation of civil rights in this country. I want to say something about security certificates. I want to say something about the corruption of our immigration review boards, with particular reference to a current case in Montreal, that of an unfortunate American would-be immigrant to this country named Karl Malaskiewicz Blaze. I want to say something about renditions to torture. I don't think I need to talk in any detail about the case of Meher Arar, but some of you may not be aware that there is a recent excellent book by the Ottawa human rights activist and journalist Kelly Wither, which deals with several parallel cases of Muhammad El-Mati, Abdullah Al-Malki, Moyed Nureddin, who suffered exactly the same fate, or I mean, a fate parallel to that of Meher Arar. They were identified on the most absurd kind of, I mean, you know how you can play that game? What do you call it? Where you try and establish by how many handshakes you are connected to, let's say, Osama bin Laden. 6 degrees. 6 degrees. I can get to Osama bin Laden with 2 handshakes, by the way. Doesn't mean I've ever met the guy or care to. You know, you can get to the philosopher Friedrich Nietzsche in no time at all. That one I think takes me about 5 handshakes, believe it or not. You know, Virginia Woolf, the Queen Elizabeth. I'm 1 handshake away from Queen Elizabeth II, and so on. Right? It's that kind of thinking that led to the accusations against these people, to their rendition or their kidnapping with information supplied by the Canadian security forces to foreign countries which we knew were going to torture them. And in all of these cases, the torturers were acting on information supplied to them by the Canadian intelligence agencies. So this is one of the shameful facts of Canada's participation in this war on terror. Another one, of course, just since I'm talking about these issues now, is of course the case of Omar Khadr, who in 2003 was interviewed in Guantanamo, to his initial great joy, by a little group of Canadians. And he came to understand that they were interrogating him. And they were part of the system under which he was suffering. The reports by the Canadians indicate some degree of mockery of the fact that, he pulled his T-shirt off and said, look at my injuries, my eye, I'm blinded and so on. And they thought, oh, he's trained by Al-Qaeda to say these things. If you read the full documents, you learn that on the following day, his American interrogator observed that one of his bullet wounds was bleeding and sent him off for medical treatment. You learn that he did indeed lose most of the sight of one eye as a result of the original action in which he was captured. Now, what we have there is beyond shame, it's open illegality. We have the Department of Foreign Affairs and International Trade, one of whose officers participated in this interrogation, and we have, I'm not sure whether they were CSIS or RCMP agents, I don't have the documents with me, but we have Canadian Intelligence Service agents flagrantly violating international law and therefore also Canadian law. And we have a further violation by our own government in its refusal to act on the International Convention of the Rights of the Child, right? According to which you do not treat 15-year-olds who have been accused of being child warriors as war criminals. You treat them as children who need to be, if anything, rehabilitated. So there's the shameful refusal of our government to act. The Canadian government, by the way, stands alone in this. Other governments have said to the United States, politely but firmly, we want our nationals back from Guantanamo. And when the British said it, the Americans said, well, okay, you can have them. Canada has said, it's okay with us. You can put this child, as he was, on trial for his life. We don't particularly care that the evidence you have against him is very clearly, by evidence emerging out of the kangaroo court system at Guantanamo Bay, fabricated. We know that the officer who composed the initial report on the action in which an American Special Forces soldier was killed by a grenade changed the report, altering it from saying that the person who had thrown the grenade appeared to be someone who was killed in this action to saying the person who threw the grenade was this 15-year-old. So there's manifest fraud, and we have a government that is refusing to take action in defiance of Canadian law, in defiance of international law, to intercede on this person's behalf. So I want to say something about the kind of tragicomic case of a young American, Karl Malaskowitz-Blaze, who was arrested in 2000 by the Secret Service. He'd had some prior troubles of various kinds, of a minor sort, brushes with the law, nothing major. But he was arrested by the Secret Service because he had been making and distributing cartoons attacking a man under the protection of the Secret Service, at this time Republican presidential hopeful George W. Bush. The cartoons, I've seen them, are rather childish. They're not skillful in any way. They're things that might have been drawn by a 10-year-old. The content of one of them is quite intriguing. A cartoon from April 2001 that shows a plane flying into the Twin Towers and accuses Bush of responsibility for all kinds of things such as that. Perhaps the Secret Service had some inkling of what was to happen and were disturbed by that. I don't know. In any case, it was regarded as threats against the life of someone under the protection of the Secret Service. He was put on trial. Before his trial came to judgment, 9/11 happened. And he was told by his lawyer, plead guilty, plea bargain. You could be in prison for 20 years. You know, the current atmosphere is really bad. Take a guilty plea, you'll get 12 to 18 months. He got 5 years. 5 years for basically cartoons. Now, once he got out of prison, he was, in a fairly short period, decided to exile himself to Canada, immigrated to Canada, got into some, I think, minor trouble in a hotel or motel. The police were called, again, doesn't sound like anything serious, and found that he had a criminal record. Here's a guy who's been in jail for 5 years for threatening the current President of the United States. And so he has been for nearly a year and a half in an immigration detention center outside Montreal. Now, I just want to read to you a few statements from one of his lawyers. So these are obviously not unbiased statements, but one of his lawyers, one of the documents asking for reconsideration of his case by the Immigration Tribunal. The lawyer remarks that the tribunal was clearly biased and expressed this bias on several occasions during the hearing. This is clearly shown by the treatment given to an American psychiatric opinion produced by a doctor attached to the Secret Service, and a pre-sentencing report from the U.S. which is full of falsehoods and wild exaggeration, and that is true. I've looked at the documents, and there was a lot of stuff generated against this man that is clearly false. The tribunal clearly does not understand the importance of freedom of expression, which is protected by the Canadian Charter of Rights and Freedoms in Section 2B and also in Article 1 of the American Bill of Rights. Mr. Milaskiewicz's opinions about the Bush family are protected expressions of opinion in the law of any democratic country, as was shown before the tribunal. It is a serious error in law for the tribunal to say that Mr. Milaskiewicz was found guilty of a serious non-political crime because of what he said about George Bush. The other accusations which were brought illegally cannot be considered to be a serious non-political crime. These are clearly a pretext for persecution. The tribunal shows biased reasoning on the nature of repression in the United States. The tribunal wrongly states that George Bush was fairly elected as president. I'm glad to see the lawyer bringing that up. It's clearly an error in law to consider that the caricatures of President Bush which were done by the applicant could be the subject of a criminal conviction in any reasonable democratic state. So there you have, I've called it a tragicomedy. There are elements of farce, but of course, as with these other perversions of due procedure, we have something that is significantly messing up somebody's life. Now I'm going to be saying, I want to conclude by saying something about the Toronto 18 case, and in particular the conviction of one of the Toronto 18 accused. I want to say a little bit about the recent conviction of Momin Khawaja on another terrorism charge. But I want first to say a little bit about the war in Afghanistan, and I'm going to have to compress this radically. The American international law expert Francis Boyle has written very lucidly about this and has concluded that the Bush Jr. administration's war against Afghanistan cannot be justified on either the facts, a paucity of which has been offered, or the law, either domestic or international. Rather, it is an illegal armed aggression that has created a humanitarian catastrophe for the 22 million people of Afghanistan and is promoting terrible regional instability. I think all of that is entirely as true now as it was when he wrote it in 2004. Now, with regard to the facts surrounding the invasion of Afghanistan. Some of these facts are geopolitical. It's important to understand that the United States enunciated in 1998 and passed as an act of Congress in 1999 something called the Silk Road Strategy Act, which defined American foreign policy goals in terms of access to energy resources across Asia and the blocking of competing powers' access to these same energy resources. There's some very, very lucid and brief treatment of this in two books by Michel Chossudovsky, one of them, America's War on Terror, published in 2005. Now, part of what emerges from these geopolitical considerations is that the United States, there's very good evidence for this, had negotiated with the Taliban for a pipeline from the Caspian oil resources across Afghanistan into Pakistan and perhaps to India, but certainly to the Arabian Sea. There's good evidence that when the Taliban in the spring of 2001 said, we don't think we're interested in this anymore, that the United States at a diplomatic meeting in Afghanistan in July 2001 made threats against the Taliban regime of a war that would overthrow them and that would begin at the very latest in mid-October 2001. Right? Now, in other words, the plans for overthrowing the Taliban had a lot to do with geopolitics by this evidence and nothing whatsoever to do with the attacks of September 11th. Now, I think it's worth remembering that for a very long time, anyone who brought up this geopolitical energy politics stuff was scoffed at. No, that's irrelevant, until June of this year, when a very distinguished Canadian petroleum economist produced a report for the Canadian Centre of Policy Alternatives. His name is John Foster. The report was A Pipeline Through a Troubled Land, Afghanistan, Canada, and the New Great Energy Game. This report came out on June 19th of 2008. And quite suddenly it was generally acknowledged that indeed a $7.6 billion Turkmenistan, Afghanistan, Pakistan, India natural gas pipeline was indeed going to be constructed at American insistence in 2010. And further, that Canadian forces in Afghanistan would be assigned responsibility for protecting that section of the pipeline which passes through Kandahar province, which is where most of the Canadian casualties in the Afghan war have been suffered. Now, that was reported in the Globe and Mail on the 19th and 20th of June, 2008. In other words, what are we doing in Afghanistan? We are part of an occupation that has resulted from a flagrantly illegal act of aggression. Francis Boyle, by the way, goes into the details surrounding the absence of any evidence provided by anybody that the Taliban regime, even assuming that bin Laden were responsible for 9/11, which we know very well he couldn't have been, the absence of any evidence that the Taliban had foreknowledge or that bin Laden gave orders. Right? Do you remember the white paper that Secretary of State Powell said was going to be produced that never appeared? And then we had this mockery of a white paper published by the poodle Tony Blair, which the British press had a great deal of fun with because it was simply a tissue of confabulation and rumor. Now, this has some relevance to, I think, a genuinely troubling case. By the way, I think it needs to be said, there are several issues with regard to the war in Afghanistan. One, of course, is the suffering of Afghan civilians. If we are fighting a war in Canada that requires us to bring our entire force of, superannuated main battle Leopard tanks to Afghanistan, what exactly are we doing? Right? If our response to an improvised explosive device that kills young Canadians patrolling a road between two villages, let's say, is to call in American A-10 Warthog jets or other jets and drop depleted uranium munitions on the villages that are harboring the people we suspect of having done this, what are we complicit in? Or if our response is to send out main battle tanks to blast holes in the walls of people's houses. I mean, what else can they do? What can a main battle tank do in a largely civilian-led insurrection? So there's the grievous fact of civilian casualties being inflicted by our troops. There's the grievous illegality of the fact that we have been handing prisoners over. We are signatories to the Geneva Convention. The government of Karzai, the puppet government of Karzai in Afghanistan, is not a signatory to any of these conventions. We have been taking prisoners and handing them over to these people. To what end? Torture, quite clearly. Or abuse of various kinds. We don't know, but we can guess. I think there's also the question that ought to exercise us, perhaps more than it does, of the grievous harm suffered by brave young Canadians. We've lost something like 100 of our young people in Afghanistan. How many hundreds have been permanently injured, physically or psychologically, by what they've experienced there? We don't know. But it's many times the number who have been killed, quite clearly. And that to me is grievous harm. We are participating in the consequences of an illegal invasion. We are participating in an illegal occupation. Oh yes, it's under NATO. Well, Section 5 of the NATO Constitution is being violated. NATO, as originally constituted, was a defensive alliance against the Warsaw Pact, right? It said nothing whatsoever. No parliament of any NATO country has revised their participation in NATO to say, we now are part of an alliance that engages in aggressive war and occupations of Middle Eastern countries. So NATO has no business, Jaap de Hoop Scheffer has no business mouthing off on the subject of Canada's obligation, Canada's responsibility to participate in this occupation, which we now know from the Globe and Mail, as well as from John Foster, the petroleum economist of world reputation, is really about pipeline protection. And it seems that's what it was always about. Now, this brings us to the troubling case of Momin Khawaja, who was convicted as a terrorist, who did engage, quite clearly, in actions opposed to our occupation of Afghanistan. The people with whom he was involved in London were convicted in London of terrorist offenses planned against civilians in London. The evidence presented against him gave no sign that he was aware that the aid he was giving to these people was going to be used for anything except assistance to the insurrection in Afghanistan. Right? In other words, the Crown could not prove that he had any intention to engage in acts intended to harm civilians in Canada, in the UK, or elsewhere. Now, I think it's a very interesting case, and I'm not going to try and resolve it for you, but it's a very interesting case as to whether or not our court was right in calling this man a terrorist. What did the German government in the 1930s call young Germans who, in revolt against their government's illegalities, went to fight on behalf of Republican Spain against the German forces that were trying to overthrow the Republican government of Spain? Perhaps that's not a fair analogy. Perhaps that's a tendentious analogy. But I think we have here a very interesting issue that demands from us serious thought. If we are engaged in flagrant illegalities, what power does our judgment that that man in that particular instance is guilty of terrorism have. I want to say a little bit about what I've called elsewhere the Toronto 18 frame-up. Because I think we have, in this case, a very interesting example of the kind of fraud and confabulation that's operative very largely throughout the so-called war on terror. Now, I want you to remember that this case consists of accusations against 18 men and boys. One of them, who was initially in press reports accused of being the ringleader, one of the sort of moving spirits, was when he was arrested 41 years old. He was the oldest. He was a janitor at a Toronto mosque. He has been effectively acknowledged by the Crown as innocent. Now, in the interim, of course, his family was terrorized. This is part of the war on terror, right? His wife was being followed everywhere by sort of men in suits, by cars and so on, and terrorized by the results of the kind of whipping up of public opinion against these dreaded homegrown terrorists. On 2 occasions, the radiator of her car was shot out. And her husband, of course, is now out on bail, acknowledged as innocent, but harnessed to very strict bail conditions. It's not enough to be innocent. You still have to, be confined and hampered by the law. So that's the oldest of these people. The youngest were people of young boys of 15 at the time of their arrests. Now, one might ask, what kind of parents would you be to allow your 15-year-old son to become part of a terrorist cell? Right? You'd have to be pretty poor parents, one might think. Until one learns something about the principal government mole involved here. Now, part of what's interesting, one of the reasons I call this a frame-up, is that there were actually 3 government moles at work here. One of them is well known because he's made himself well known, a young Torontonian named Mubin Sheikh. Mubin Sheikh built for himself a reputation in the Toronto Islamic community as a young man of deep piety, of humanitarian commitments, and also of experience with young people. He spent his teen years as a Canadian Army cadet and sort of advanced to the highest rank one can enjoy as a Canadian Army cadet. He'd done paralegal training at the University of Windsor, so he worked at one of the Toronto mosques as a conflict resolution specialist. He was a very noisy advocate for Sharia law some 4 years ago when that was controversial in Ontario, to the point at which many of his co-religionists said, Mubin, can you just tone it down a little bit? Just shut up, in fact. In other words, if I were the parent of a 15-year-old who said to me, Dad, I want to go paintballing this weekend, and it's being organized by Mubin Sheikh, I'd say, okay, he's a solid guy, sure. Why not? Have fun. What the parents didn't know was that Mubin Sheikh was a drug addict, very serious drug addict, and I think there's reason to suspect that he may have been reeled in by the police and used, manipulated, or he may have been wanting to feed an expensive habit. But he was paid, there are different accounts of how much he was paid, but I think it adds up to $377,000 by the Canadian state for his work in creating the appearance of a terrorist group. Now, one of the places where they had a terrorist training camp happens to be very close to the village I lived in, Eden Mills, not far from Guelph, for about 10 years. I know the conservation area where they did their training. The idea of a terrorist training camp occurring in the Rockwood Conservation Area is literally hilarious. It's about, maybe 3/4 of a square mile, this very pretty little dammed up area on the Aramosa River. There are some quite beautiful native rock paintings on some cliffs on one side of the pond. You can rent little plastic canoes and paddle around in the pond, and there's a camping area and so on. I mean, this is not a place where you do terrorist training. So that's one of the places they went to. And Justice John Sproat, who convicted one of these juveniles in an Ontario court at the end of September, accepted that material as evidence of a serious training camp. He said, well, of course terrorists do things like rafting. And you know, I mean, rafting on the Aramasa River, I assure you, is an impossibility. So mole number one, his job basically was to create the appearance of a group. You can call this speculation if you like. So put square brackets around it. These are Keefer's speculations as to what was going on. To take them for expeditions in the country, which he subsequently represented as terrorist training camps. Now, I think we have to give him some credit, because in the trial of the young man who was convicted, Mubin Sheikh, the chief crown witness, was insistent that this young man knew nothing of any terrorist intent. And here I think we need to contemplate the meaning of the corruption of Canadian law by anti-terrorism legislation, Bill C-36, etc. Because the evidence that the judge accepted flies in the face of traditional common law legal doctrine. The common law tells us that to secure a conviction, you need to have two things. You need to have the actus reum, which is the guilty act, that needs to have been done, and you need to have what's called mens rea, the intention, the guilty intention to do that act. In other words, if somebody does something that's a crime and it was purely accidental, we don't punish that as, first-degree murder or whatever, right? So there's actus reum, mens rea. This young man was convicted by a court that effectively took that essential common law criterion of mens rea and threw it out the window. What he was guilty of, basically, is shoplifting. He shoplifted stuff that Mubin Sheikh told him the group needed for their camping expeditions. And Mubin Sheikh said, listen, we don't want to buy this stuff legally, right? We want to get it illegally. You go and steal some flashlights or whatever. I don't remember the details, but it was pretty harmless stuff. So this kid stole stuff at the instigation of a very highly paid government mole, who then in court says the kid knew nothing about any of the terrorist stuff that I am imputing to other members of this putative group. And he's convicted as a terrorist. Now that to me is blindingly stupid. How can we be so stupid? How can we permit our judges to be so stupid? How can we permit our parliamentarians to be so stupid? That boy's life is ruined. Right? Now, another mole number two. Oh, by the way, Mubin Sheikh decided that he'd undersold himself. He came back last year and said to the RCMP, I want 2.4 million. In return for which, I will promise not to make any book contracts or movie contracts. And I'll stay off drugs. He promised three things. Mole number two was paid 4.1 million. And I think this may be what rankled with Mubin Sheikh, $4.1 million. Mole number two, who remains unidentified, Globe and Mail and Maclean's magazine know who he is, but he's under the witness protection program. He is an agricultural engineer whose job appears to have been to, now the timing here is interesting, because in the spring of 2006, Mubin Sheikh reported to his RCMP handlers that the group, by his account, was getting ready to do sort of explosive stuff. What does the RCMP do? Well, you'd think they might think of arresting people if they have clear evidence of a group that's planning to set off explosive detonations in Toronto in the very near future. What they do instead is to hire an agricultural engineer who can provide supplies of ammonium nitrate fertilizer for ammonium nitrate fuel oil bombs, Timothy McVeigh. This is part of the scripting, right? Homegrown terrorists, Timothy McVeigh type, make fuel oil bombs, make fertilizer fuel oil bombs. Mole number 2, according to Maclean's magazine, provided them, the group, with the credit cards necessary to make the purchase, as well as the stuff itself. Well, they never actually got the stuff. The RCMP, I think, provided them with a bag of something else and then swooped and arrested everybody. They also had a third mole. This came out only later. A third mole who apparently was the one who provided the initial idea. Let's make a fuel oil fertilizer bomb. So you have one mole that creates the group. You have another mole who provides the idea for the central crime they're going to be accused of. You have another mole who provides, the necessary stuff. At what cost to the Canadian taxpayer? $4.1 million to the agricultural engineer. We don't know how much to mole number 3. $377,000 to Move and Shake. A lot of money to his handlers and the various CSIS RCMP people who, time's up. Okay. I just want to say in conclusion a couple of things about issues of torture. One feature of that case is the mistreatment of the men who were arrested in the Canadian prison system. They were subjected to sleep deprivation torture, as was Omar Khadr in Guantanamo. They were subjected to abuse of other kinds, to beatings, to solitary confinement for very extended periods of time. Ontario's Solicitor General thinks that's quite okay. I think it's important to understand that there is a kind of equivalence involved here between a state that says the crisis we are facing is such as to require us to move from our normal legal regime into a state of exception. That's what happened in Nazi Germany, right, with the Reichstag fire. That's what's happened, in effect, with the Patriot Act in the United States. The United States has moved into what appears to be a permanent state of exception, in which the normal civil rights no longer function. And something similar has been happening in Canada. It's visible in the case of Karl Malashkowitz Blaze. It's visible in the case of the Toronto 18. It's visible in the case of the behavior of our security forces in relation to people like Meher Arar. Now, we have two correlated things, I think. We have what some political theorists refer to as a sovereign exception, in which the ruling power expresses its sovereignty through the very fact of not subjecting itself to the rules that it applies, the laws it applies to everyone else. Sovereignty consists of exempting the sovereign from the law that applies to everyone else, right? Where does that doctrine come from? It comes from the Nazi jurist Carl Schmitt and his book. Corresponding with that is the doctrine that goes actually right back to the European witch trials of the 16th and 17th century of defining certain crimes as a crimen exceptum, a crime that is so horrible that we do not apply our normal judicial categories to that crime. And that's clearly what the war on terror amounts to. It amounts to a parallel exemption of the sovereign power from the laws which it itself applies to everyone else, and a declaration that certain people, Muslims, are going to be judged as a different category. And the things we accuse them of are so horrific that we can't contemplate applying our normal judicial procedures to them. So what I'm suggesting then, in conclusion, is that we're facing not merely an engagement in a flagrantly illegal war and occupation, about which we have been lied to consistently, but we are facing a systematic degradation of our charter rights, of our judicial system, and of our police system. Thanks.
Thank you, Professor Keefer.